Hi there, my dear friends. I am back, Dean JOE-SANTOS Balagtas BISQUERA, on a subject matter that I've been so eager to talk about with you. Being a lawyer, CPA, and because of my extensive experience in the corporate management world, I have always been known to have expertise in commercial law, taxation. But this is very funny because when you talk about law practice, commercial law is dominated by the big law firms in Makati, and it is very difficult to compete with them when you talk about the big law firms. The same is true with taxation, where even the big CPA firms would offer tremendous competition with you. So, you can essentially become quote unquote an expert in the subject matter of commercial law and taxation, more on the academe and of course in these YouTube uploads. But in my how many years? 27 years experience as a practicing lawyer, the fields where I have been extensively involved in is criminal law, followed by labor law, and of course the area of civil law where family relationship, particularly annulment of marriage, becomes a very dominant thing. Now, among us who will go into practice, take note that the field of criminal law is really one of the most prolific fields, and you have tremendous opportunity to really practice law here. Like the Department of Justice is not involved in civil law or taxation. I don't even think they're involved in political. They're heavily, in criminal law because they handle the public prosecution side. All the public prosecutors are on the side of the Department of Justice. And so, what else would they be working on except criminal law? None. When you go to the public attorney's office, because you've got the battery of public prosecutors on one side, obviously the opposite side, the defense, would be equally contending with this big chunk of public prosecutors. So the public attorney's office would equally be heavily loaded with criminal law. And so finally, we end up with our individual practitioners where I belong to. And definitely, every person who comes to me is heavily under stress in the involvement on criminal cases. And so this is a very beautiful subject matter to deal with. Now, the other area where I really enjoy working with is labor law, where assuming nobody is listening, I am rated to be one of the private practitioners who made tremendous money out of labor cases. And the funny thing about it is I am a management man. And almost all, I think all of my labor cases are defending the workers. And perhaps my advantage is because I come from the management sector. I can understand how the labor lawyers for the management would be attacking the problem because I was in that situation as part of management. But in all fairness, it doesn't always mean that management is always right. And that's precisely where I come in very strong because I know where management can come in. And I'm referring to a certain segment of the employers who are really, if I may be kind to them, abusive of their rights, and to the prejudice of the workers. That is the reason why I don't feel I have worked with a lot of good employers, multinationals, even local companies, even that would even include Chinese corporations. I've worked very well with the Young family of Permaline, And I'd like to make mention about how good and how honest and how compassionate my immediate superior there, Michael Young, was. When we were negotiating, I was heading, of course, the management panel on this collective bargaining agreement. And Michael Young, you can see his idealism, his desire to give everything to our people so that our people would have all the comforts and would dedicate themselves to it. And that was when I learned that you can only give half of your love and care for the your rank and file workers, because a major group that's in between management and labor are the so-called federations. And I'm not referring to all federations. I'm simply referring to my own limited experiences dealing with respectably large federation labor unions. And I was shocked to learn that my idealism could be compromised by the lack of it dealing with the supposed guardians of welfare of labor. Anyway, our subject matter today is one of the most interesting topics, and this is the questions in the 2022 bar examinations on criminal law. In the past, I have always had been invited, for example, in the Philippine Judicial Academy, to speak about some cases, some speaking engagements on very beautiful concepts in political law. There are also some invitations from the local governments, especially the province of Bulacan, where I was supposed to speak side by side with a Malacanang bigwig who did not come, and I was the one who came, and I didn't have that kind of very famous name, and so I was talking to the very young vice mayors of Bulacan, and I heard their whispers during lunchtime. They said they will all be closer to the door, so that after I deliver my first 30 minutes, they would slowly sneak out. So I felt very sad. But I talked about this exactly concept of socio-economic development that should be nurtured at the lower level, and finally federalism. And the compliment I got there was they did not walk out. They did not stick out. Many of them who were at the door started moving up on the front line. And at about 3 o'clock, when I am already, perhaps, who knows, 45 minutes past my timetable, during the open forum, somebody stood up and said, Dean Bisquera, we are surprised to hear about how good a speaker you are and how idealistic. Our only question is, why are you not in the political arena? And I said, because I was born poor. And unlike you, who are vice mayors, you come from political clans and you already have a franchise for your political positions. I was born, I said, and I grew up at the back of Loreto Church in Sampalo, walking to school and barely surviving with 30 centavos, all through my elementary and high school and college years. And so I was more focused on just trying to survive and finish my work. And I got married so early. I was focused on trying to provide some respectable thing to my family. And that's the reason why I became a lawyer at the very late age of late 40s. And good, I'm still here. And thank you very much for somehow not walking out on me, because I heard you wanted to just slip out after 30 minutes. They all laugh. But the biggest compliment I had was when I was getting assignments, more as ano bang tawag doon? Panakip-butas, substitute in the likes of Sandigan Bayan Justice Rodolfo Palatao. And then you speak after the great speaker, Justice Edilberto Sandoval, who was the head of the Criminal Law Department of the Philippine Judicial Academy. When you have brilliant, justices who are experts in criminal law with that kind of caliber, and then you are asked to speak about some little things also on criminal law, how do you expect to really match the support and adulation of their audience? So one time I was invited to pitch in for Justice Rudy Palatao, and he told me, "Hey Joe, they gave me anti-money laundering." Sabi niya, tamad na akong mag-aral ng bagong mga batas. Kung book 1 at book 2 yan, mamaniin ko lang. Pero anti-money laundering, then later on, anti-terrorism also. Pero anti-money laundering, can you just substitute for me? Kasi I have 2 other conflicts. Well, the long and the short of the story is when I opened the discussion on the anti-money laundering, I dropped the bomb by saying, did you know that anti-money laundering started with Al Capone? And the audience, about 60% are trial judges and the balance are veteran lawyers. This was a PhilJA, Philippine Judicial Academy, and IBP-sponsored, MCLE. They were so silent because they didn't know that there's a linkage between money laundering and Al Capone. And so I said, we had a earlier speaker, Justice Edilberto Sandoval, and I really do not know how I can survive. He ate up about 1 hour of my time, and we have a fixed timetable, so I have barely 45 minutes to finish this, and I don't want to hold you unnecessarily. The long and the short of the story is after I ate up already their time for more than 1 hour, so it was 2 hours. And I cut my speech and said, I am already taking too much of your time. Some of you must have your commitment, so let me cut off my talk now. And I made sure, nung pinutol ko yun, yung palang yung nakabitin yung paano ba nagkaroon ng money laundering involving si Al Capone. So tapos medyo pinipitik-pitik ko na yung issue ng yung money laundering. Nagsimula talaga yan when Al Capone started buying in San Francisco most of the laundry shops. Talagang doon ang galing yung word na laundering. Oo. Dinideposito niya yung illegal money niya doon sa mga collection na kasama ng mga laundry shop. So, kung for example, $1,000 yung laundry shop, i-deposito niya 10,000. Yung ika-11, legal money, yung 10, yun na nanggaling sa kanyang pag-smuggle ng liquor. Oh. So, pagpasok sa bangko, hindi mo na makikilala yon kung alin doon yung dirty money, yung $10,000, tsaka yung clean money ng laundry. O, di pasok ng pasok ng pasok. And so that was how money laundering came into being. Biniting ko. Nung pagkatapos ko nun, sabi ko, at least natutunan nyo na. And I still have a number of slides probably for another 30 minutes. Tsaka na lang ho natin. Hindi pumayag. Sabi nila, Dean Bisquera, tuloy. Nobody went home. And because of that, I was finally called by the late chairman, Justice Amirpina Melesio Herrera. And Rudy Palatao was scolded. Sabi niya, how have you been hiding this Dean Bisquera? You never even told us that he can be part of Philippine Judicial Academy. So he was inducted. Hindi professorial lecturer 1, professorial lecturer 2, ka-level ng mga retired justices. Dahil lang dyan sa lintik na money laundering. So criminal law was really has become part of my love. So ngayon, tingnan natin. We have a lot of interesting hypotheses dito sa bar exams ng criminal law. And I would not consider criminal law that easy. Madaling sagutin. Pero ang question, yung sagot mo ba na madali, tama. There are some and I'll talk about that. No? I'll give you the usual format. I'll read the problem. And I will give my suggested answer following yung guideline ko na short sentences, simple words, direct to the point. Pero to explain further, i-adlib ko na hindi nakasama rin sa suggested answer para lumawak. Pero my suggested answer is very short. I think that is already more than sufficient for a candidate to get a perfect score. Yung burloloy na lang yung paliwanag natin para naman masaya itong get-together natin. May nauna ng dalawa na nagbigay ng version ng kanilang answer dito sa criminal law. I felt so slighted on myself and against myself because of all of this technology that ambushed me for the past almost 1 month. Ngayon lang ako nakakabawi. And so, if my answers, pare-pareho kami ng sagot, one is a public prosecutor, the other one, parang ang impression ko, he just took the bar. And he was young, very aggressive siya na mas maikli yung mga sagot niya at diretso rin. No? Pero there was one answer he had that I felt hindi yun ang tamang sagot. So let's take a look at our thing. As usual, I will group them and I will go through the structure of my answer as we go along. Natutuwa ako dito sa kurtina natin. This is part of the latest MS Office 365. This one, huwag na nating pasadaan ng gusto. Only for those of you who have not been watching my my slides or my YouTube uploads, para sa inyo yan. But bahala na kayong humimay niyan. You can always stop naman and take a look. I am not changing this. And so let's move on to the next slide. And you will notice malinaw na malinaw criminal law. And this will change depending upon the field we will be talking about. In this discussion, just like what I did with political law and civil and commercial law, we're dividing criminal law into the 3 areas which were covered by way of the questions raised. So by way of sorting out, there were questions on the principles of criminal law, and we'll see the topics under that in the next slide. And then there were questions on the revised penal code, obviously. But there were tremendous questions also on special criminal laws. Of course, some of you have tried to master criminal law, that this is essentially malum in se, and this is malum prohibitum. Pero hindi naman ganun ka-strict kasi you will notice there are also special criminal laws that are malum in se, hinabol, hindi umabot ng ginawa yung revised penal code. And so of these 3, let's take a look first at the principles of criminal law and the questions that were given here. Okay, so the questions in principles of criminal law handled the proposal to commit murder, the accessory after the fact, criminal liability upon death, malum prohibitum, and PRAETER intentionem. You will identify most of these are essentially under the topic of principles of criminal law. And we will talk about that in a little while. The second grouping is the revised penal code. So yun, kanina, 5. Ito, there is a question on chastity and 3 yung properties. 2 are theft. Pareho pang cellphone. Ewan ko bakit na-overlook yun. Tapos a question on robbery under property, and then liberty and security, dito may kidnapping. Now, you will notice here that I am very particular about pinpointing possible compound or complex crimes because posibleng ma-overlook yun. And the other one is if there is, of course, some aggravating circumstances, and there are, no, na-involve yung police, for example. Tulad dito, merong kinuhang cellphone na in the process of serving a search warrant. Siyempre, pagka nagsaserve ka ng search warrant, police ka, kinuha mo yung bagay, you must be abusing your position as a public official. Diba? Yun, baka hindi mapansin yun. So, tingnan natin. Tapos meron dito rin question ng robbery. Ito naman, medyo tingnan natin kung ano yung laman. And then, on the special criminal laws, there were questions on special protection of children under Republic Act 7610, yung anti-violence versus women and children, yung battered wife concept under Republic Act 9262. Pumasok yung Data Privacy Act, nasama na rin ito, if I remember right, sa political law. Tapos yung Safe Space Act, yung bawal yung bastos. Ito binigay. May mga cases ako dito. Yan, anti-violence, actual cases. And then ito, nagbigay ng bonus grade in Determinate sentence. So you can see here that there are 5 questions in special laws. At yata ng posibleng special law, binigay. Pagkatapos meron din 5 questions dun sa 6 pa. Yata, dun sa, what you call this, revised penal code. And then 5 din sa dun sa principles of criminal law. So with that much ado, let's take a look at this one. Balikan natin uli yung heading. So we'll go to the details now of the principles of criminal law. So ito na yung 5. 1, 2, 3, 4, 5. 5 questions in the subject matter of principles of criminal law. The first question has something to do with the proposal to commit murder. Okay. Ang ginawa ko nito as they come within the principles of criminal law, yun ang nakalista sila rito. So at least pag nidiscuss tayo, nakagrupo na principles of criminal law, tapos nakagrupo din yung problems referring to the revised penal code, tapos nakagrupo din yung tawag dito yung special law. So merong sistema tayo na nakafocus tayo. Kasi pagka diniscuss mo, sunod-sunod, parang chapsuy, hindi mo ma-focus yung principles. No? So let's take a look at the proposal to commit murder. The question that was asked on the proposal to commit murder runs like this, and it is problem number 9. It says, during one of their intense operational meetings, the campaign manager of a presidential candidate openly suggested, dapat ipapatay na lang natin ang mga bumabati ko sa kandidato natin. Later, the campaign manager was charged with the crime of proposal to commit murder. Can the campaign manager be convicted of the offense charge of proposal to commit murder? Our suggested answer, no. The campaign manager cannot be convicted of his proposal to commit murder because there is no revised penal code provision or any special criminal law that provides a penalty for such an offense. And that is under Article 8 of the revised penal code. And then reiterating, yung conspiracy and proposal to commit rebellion, that is provided for under Article 138. So yun, pag doon ka, nag-conspiracy ka, nag-propose ka ng rebellion or insurrection, then you can be brought before the courts for prosecution under Article 138. Yun lang yung merong law on penalizing propositions. Pero to propose murder or patayin, proposal to commit murder, wala. There is no law on that particular thing. Naalala ko tuloy si Mayor Fred Lim one time. Tinawag kami ni Justice Rudy Palatao. Sabi niya, Rudy, Joe, ano kaya mag-privilege speech ako? Sabi niya, napanaginip ko na-pinpoint ko kalahati nitong mga senador na kasama ko. Mga corrupt, and I have personal knowledge. Kung ikwento ko sa public sa aking privilege speech na ang panaginip ko, pinagpapatay ko sila. Will I be liable for anything even under the rules of the Senate? Pwede ka bang palisahan na kinento mo yung panaginip mo? Naluma ako Up to now, I still don't know the answer. Because, for example nagle-lecture tayo rito sa YouTube. Pwede ba ako mahabla rito ng anything kung nasabi ko na panaginip ko, for example? Ganun. Napanaginip ko, pinatay ko si ganun. Napanaginip ko, hinalikan ko si ganun. So that was the question that was brought to us by Senator Lim that time. Si Justice Rudy is very smart Sabi lang niya, Fred, huwag mo nang gawin yan, sabi niya. Kasi baka hindi compatible dun sa image mo bilang senador. Mangyayari lang, parang lalabas dirty Harry uli ang picture mo. Iniwasan mo na maging dirty Harry image mo. Sabi niya. Nagtawa na kami. Tama, hindi niya tinuloy. Okay, so that is the first question under the rules on principles of criminal law. Wala, there is no law that will prosecute you for the proposal to commit murder. Second question, accessory after the fact. So again, part of the principles of criminal law. Baba natin ito ng konti para makita yun. Kasi may lalabas dun later na. So here is the question. The question on accessory is problem number 11 and it reads like this. In an act of rage while playing golf, a high-ranking public official hit a caddy with a golf club at hole number 9 of a golf course. The caddy fell and died immediately. The public official called a loyal security guard who did not witness the incident. The security guard was instructed to put the caddy's lifeless body in the golf cart and dump it in the nearby lake. The public official wanted to make it appear that the caddy died of drowning. The corpus delicti of the crime was discovered. Both the high-ranking public official and the security guard were charged as co-conspirators for the crime of homicide. Can the security guard be convicted as the principal to the crime of homicide? Explain briefly. Our suggested answer, no. The security guard cannot be convicted as a principal. He did not directly participate in the caddy's death. He did not force or induce others to commit the offense. He had no indispensable cooperation in the killing because he was not present during the said killing. The guard is an accessory after the fact. He concealed the body of the crime to help the public official. And so that is how simple the answer is. Essentially, the question revolves around who is a principal. Take note that there are three principals in a crime. And I will enumerate them according to their sequential role. First, you have the mastermind, and he is the principal by inducement. No? Siya yung talagang taga-sulsol. So siya talaga yung unang ilalagay. And the principal by inducement may or may not be present. Usually pag mastermind ka, chances are nasa distance ka o nagmo-monitor ka kung ano nangyayari. So it is possible you are not in the scene of the crime. Obviously, yung principals by direct participation, nandun lahat yun sa crime. Ang mahirap, yung pangatlo, yung principal by indispensable cooperation. Kasi depende yung how indispensable is cooperation is. Because pag bumaba ng konti, he now goes into the category, the second category, who is an accomplice. No, na-accomplice. Kaya matatanda mo, na-accomplice sa tulong niya. Pero hindi indispensable, so hindi siya principal. So, yan na yung dalawa, principal and then yung accomplice. Yung accessory, most of the time, wala yun doon. Pag nangyari na yung crime, no, he comes in after. And the biggest role of the accessory, kaya nga always label is as accessory after the fact, so you don't get mixed up with accomplice. No? Ako dati-rati, naguguluhan ako sa accomplice, accessory, accomplice, accessory. I developed this little trick. Pag accessory, parati ko nilalagay ng burloloy after the fact to emphasize na wala siya doon sa scene of the crime. So he cannot be a principal, he cannot also be an accomplice. Yung accessory, malino naman, wala doon. Anong major role niya? Normally yung accomplice, no, he is the one that helps the principal either to escape. Yun. Siya yung taga-drive. Second, he may be the one to help out. Nakaalis na yung mga siya magtatago nung yung corpus delicti. Either yung katawan, ililibing niya, tatapon niya, or yung pera, itatabi niya. So makikinabang pa siya doon. Yun ang mga role na accessory after the fact siya. And so, he cannot be a principal kung wala siya doon, except kung siya ang mastermind. Yun ang napakalinaw na explanation kung bakit yung kadi hindi pwedeng maging principal. To my mind, a regular bar candidate would be able to answer this easily. Nasa basic sa akin yun. No? Pag hindi mo alam yan, mahirap na maging abogado ka. Maguguluhan kayo. Okay. The third question is something to do with the criminal liability of a respondent, no, when he dies during the time that his case is subject for review. So, ano bang effect kung siya ay namatay during the time he is appealing his case? So, the accused death, criminal liability. The question, which is problem number 13, was a prisoner who had been convicted but whose appeal was pending died due to complications caused by COVID-19. Should the prisoner's pending appeal be dismissed as a consequence? Explain briefly. My suggested answer, yes. The petitioner's pending appeal should be dismissed. Criminal liability is totally extinguished as to both the personal penalties and the pecuniary liability when the death of the offender occurs before final judgment. So may sentence na on trial. It is before either the Court of Appeals or before the Supreme Court. No? Why would the appeal be dismissed? From the criminal point of view, when he dies, how can he ever answer for the penalty? Hindi mo naman pwedeng ikulong yung patay na. Kung death, patay na rin. Assuming there's the penalty. Now, insofar as the civil liability is concerned, the hypothesis is any civil liability from sources other than the criminal offense may proceed as a separate civil action. Kumbaga remember, his civil obligation comes from dolo or from violation of a criminal law. But if his obligation can still be derived from contracts, from quasi-contracts, no, from quasi-delict, or from the law itself, no, then you can proceed against the estate of the accused rather than proceed with the criminal offense, no, na nakasama yung civil action. Yun ang suggestion na dapat gawin when there is this thing. And you notice merong decided case bagong-bago. People versus Mylon, and that is on June 2020. Relatively very new. So definitely binding effect. So criminal liability is no longer due and demandable upon the death before final appeal, before conviction or appeal. Okay. So, moving on to the next one. Nakakatatlo tayo. Ay, umulit, no? Siguro mali yung kodigo. Baka bumalik-balik. Okay. We will have to just manipulate a little. Nagkaroon lang ng konting aberya yung yung tawag dito, yung link up, no? So, balikan natin. Nandito tayo. And we were already done with this. Nakakatatlo. Ito na ikapat. Malum prohibitum. Let's move on. Yun. Problem number 14 on malum prohibitum, it reads, a person arrested for playing carry cruise was charged with violation of Presidential Decree number 1602 or the anti-gambling law. The lawyer for the accused argues that the case should be dismissed based on an exempting circumstance, which is that the accused is poor. The lawyer argues that unlike those who gamble in big casinos with astronomical sums of money, carry cruise is the accused's only means of entertainment. In addition, the lawyer explains that gamblers from China, where gambling is illegal, are even welcomed in the Philippines. Is the lawyer's argument legally tenable? Explain briefly. Well, if you were the judge here, hahambalusin mo lang sa ulo ito. Exempting circumstance. Wala namang being poor as an exempting circumstance. Diba? Oo. Ano relasyon nun dun sa anti-gambling law in terms of yung mga casinos, malakas magpano? Separate yung batas na yun. So, let's take a look at the suggested answer. The lawyer's argument is not legally tenable. Carry cruise in the Anti-Gambling Act is malum prohibitum. It's basic. Good faith or motive to include that the prohibited act is fit for the poor's entertainment is irrelevant and not an exempting circumstance. The law simply punishes the prohibited act. Napakasimple lang. At ano pa yan, no? 2015, meron hawig na kaso, Sagin versus People, na ginamit yung principle na malum prohibitum, walang kutsi-kutsi, basta pinagbawal. Bawal ang gambling, walang mga exempting circumstances na justify, wala ganun. Basta malum prohibitum. Hindi pwede. Tapos. Oo. Ito na naman yata. I think the, what you call this, the linkage is not working. So, balikan natin. Maganda pagka ikaw ang gumawa ng slides mo eh. Alam mo kung saan ang butas eh. Kung may ibang gumagawa dyan, tapos nagloko ng ganyan habang ini-slide mo. Lalo na kung actual live presentation, di mo alam, yari ka. Minsan kasi talaga, minsan naglolo ko yung tatlong beses ko pinasadaan ito kanina para smooth. Pero I expected worst scenario. So, ito na ngayon, yung paborito natin, di ba? Yung achong case, yung mistake of fact. Tapos meron yung aberratio ictus, diba? Error in persone. Tapos ito na yung pang-apat, praeter intentionem. Tingnan natin, ito napalakas daw. O yung hindi intention na gawin, may nangyari mas malala. So the last question on the principles of criminal law runs like this. Number 15 ito. While attending to an enhanced community quarantine barangay checkpoint, a barangay tanod confronted a resident for non-essential travel. Infuriated by the barangay tanod's tone, the resident punched the tanod's head. The barangay tanod fell, sustained brain hemorrhage, and died as a result. Charged with homicide, the resident denies liability, arguing that there can be no conviction if there is no intent to cause the barangay tanod's death. Is the resident's defense tenable? Explain briefly. Okay. Answer, no. The resident's defense is not tenable. The resident incurs criminal liability because his act of punching the tanod is the felony of physical injuries. So, sinuntok mo, physical injuries, resulting to death, comprising homicide. Sinuntok mo, dapat nasaktan lang, tumumba na matay, may homicide na. The wrongful act of homicide may be different from the intended physical injury of punching the tanod. But the resident becomes liable for homicide even when that was not the felony intended. Ganun talaga eh. And that is provided in Article 249 of the Revised Penal Code. Pero talagang praeter intentionem is in Article 4, Paragraph 1. That you can be held criminally liable for the resulting act even if that was not your intended offense. Okay. Yun lang. Simple. Praeter intentionem. If you notice, our answers are direct to the point and too short to even be questionable. Conclusive kagad yung sagot natin. Yan, umuulit na naman praeter intentionem. Hindi umuubra talaga yung ating link up doon. So that we already are through with the principles, no? Ito na yung ano natin. At natapos na tayo dun sa principles of criminal law. Where what was given is 5 questions: the proposal to commit murder, the accessory after the fact, yung kadi na tinulungan ng security guard yung namalo, yung criminal liability upon death, yung malum prohibitum yung gambling, tapos yung praeter intentionem, nasuntok yung tawag dito, barangay tanod, matay tuloy, hindi naman ano lang, physical injuries. So we're about to go back to our summary table, which will tell us, tapos na po tayo sa 5 problems of principles of criminal law. We're now moving to the main event, which is the revised penal code. So let's take a look. In the revised penal code, what was asked is on the subject matter of chastity. Then there were 3 problems on property. Dalawa sa theft, isa sa robbery. And then finally, there is a question on the liberty and security dito may kidnapping. So let's take a look first at this particular subject matter on chastity. Ito medyo may controversial dito. Hindi umubra. Tingnan natin ulit. Ayun, umubra. So this is problem number 1. Pagbukas mo, ito kagad ang problem. And let us read. Interviewed for a newspaper, a former beauty queen revealed that when she was 16 years old, she had her first sexual intercourse with her ex-boyfriend, who was then 28 years old. In the narration, she said that she did not know what she was doing and noted that her ex-boyfriend of a more advanced age misled her to doing what he wanted. She added that at certain points during the encounter, she repeatedly said no, but her ex-boyfriend was too strong for her. The ex-boyfriend left her shortly thereafter. Was there a crime committed by the ex-boyfriend? Explain briefly. My suggested answer: yes, the ex-boyfriend committed simple seduction. Let me repeat. My position here is that the crime that was committed was simple seduction. In having carnal knowledge of the beauty queen. She was then single, over 12 but under 18 years of age, and was misled in deceit on her first sexual intercourse to do what the boyfriend wanted. So here I would strongly insist that the crime committed based on the provisions of the revised penal code is simple seduction. Now, may mga sumagot yan na ang sagot rape. Meron ding sumagot ng child abuse. Now, let me just address this not as part of the answer. No, ito na yung answer na ang tingin ko, mamaliin lang, itatama lang ng examiner. But if the examiner is thinking about child abuse, the boyfriend cannot be held for child abuse. He did not intend to debase, degrade, or demean the intrinsic worth of the beauty queen as a human being. No? Kasi ang child abuse, merong nilagay na yung isang nagsuggest, nilagay niya yung Republic Act 7610, I think Section 5B yata. Pero there is a need to call attention yung case of Kalawagan versus People, which is very new, no? March 2019. Dito, sinabi ng Supreme Court na for child abuse to prosper as the offense, dapat the act of abusing the child is intended to debase, degrade, demean the child. Dito, ang objective nung ex-boyfriend, hindi naman debase, demean eh. Hindi, gusto lang niya magpasarap. So, ano siya? Seduction. Meron siyang L. Hindi niya hinihiya yung beauty queen. And then, rape will not also prosper because rape cannot prosper here because the beauty queen personally admitted the one was her ex-boyfriend. And after a series of sexual intercourse, tinanggap na niya yung mama na boyfriend. Pwede pa nagpakasal, di lalong natapos. Wala talagang rape, no? Pero the presence of the word boyfriend that came from her, you know, in effect, fits into her declaration of the sweetheart theory, a strong defense against rape in favor of the accused male. Di ba one strong defense is i-offer mo na lang if you are the one accused of raping the woman, is to offer the woman, assuming she's capable of marriage. Wala na, tapos na. But close to marriage, sasabihin ng lalaki, hindi, sweetheart ko yan eh. Talagang nagkagustuhan kami at talagang nagpasarap kami. O proof. Maaaring may konting pilitan doon sa una. Umulit-ulit kami. Oo. So yung second, third, fourth at sunod-sunod na. Kaya nga naging boyfriend niya ako eh. Masaya na siya. No? Kaya lang, hindi mo bubura yung simple seduction on the first sexual intercourse dahil binola niya eh. Oo. Therefore, virgin yun. No? Sabi nga kasi first, the virgin. Tapos 18 years old. So yun, that will fit into simple seduction. I remember my criminal law professor, si Atty. Rojas. Diyan matinik si Atty. Rojas eh. When everybody thinks rape yan, katulad dito child abuse, bigla niyang pipitikin yan. Hindi, simple seduction. And he will highlight kung bakit. You know? And I probably am so enthused with him. No? Na hindi ko alam kung he has already passed away, but he's a contemporary of my parents. Magkaibigan sila. And he was my professor in criminal law. But at the UE College of Law, kahit na sabihin mong hindi siya nasa kategorya ni Justice Sandoval at Justice Palatao, talagang lahat ng estudyante ni Atty. Rojas talagang hirap doon sa examination. Yung mga professor sa criminal law natatawa rin eh. Kasi siguro hindi rin nila masagot. Ang hirap magtanong because he is able to manipulate a little of the facts so that it does not easily fit into the thing. Katulad nito, hindi parang fit na fit sa child abuse, fit na fit sa rape. Pero wala siguro maraming makakaisip na based on the elements of the offense, it is really a simple seduction. I submit that this particular answer is the correct answer. Okay? So yun ang unang-una under the revised penal code. Now, the second problem in 5 would be a crime on property. Tingnan natin. So, theft ito. While executing a search warrant, a police officer pocketed and absconded with the mobile phone of the occupant of the premises being searched. The mobile phone was not the subject of the search warrant. It was not enumerated in the order. murder. Did the police officer commit a crime? Explain. You know, I think almost 9.5 of 10 candidates on the bar will be able to answer this. Obvious na obvious yan. No? Theft yan. Wala namang force upon things eh. No? Kaya lang, when I was looking at this, may booby trap ng konti. And I'd like to call your attention to this because some suggested answers did not consider this. My answer is yes. The police officer committed theft, but with an aggravating circumstance. When he pocketed the cell phone without the occupant's consent, with intent to gain, but without violence against or intimidation of persons nor force upon things. Eh, yun naman ang definition ng theft. But I would give a perfect answer if this one is included. The offending police officer took advantage of his public position as an aggravating circumstance. Eh, nagpunta siya rin, may search warrant siya as a police officer. Eh. O, nakita niya yung cellphone, di naman kasama dun sa search warrant, binulsa niya. No? Kung ordinary lang siya magnanakaw, okay na. Eh, hindi police officer siya. So there is really taking advantage of his public position. May dala-dala pa siyang search warrant. So I'd like to under Article 14, there is taking advantage of public office as an aggravating circumstance. So yun ang suggested complete answer ko on this particular question. Kung ang sagot ay theft lang, may hindi perfect yung answer. Okay. Another problem number 3 under the revised penal code is also theft. Tingnan natin. During the Senate hearing in aid of legislation, a senator's staff member took a resource person's mobile phone without their consent or knowledge. Siguro yun without his consent kasi person. While the hearing was ongoing, the staff member read the resource person's messages contained in the mobile phone and hurriedly wrote notes which are passed to the senator. Thereafter, the staff surreptitiously returned the mobile phone. The resource person would not have noticed that the mobile phone was taken had it not been for a TikTok video posted by a journalist who was present during the hearing. The TikTok video caught the entire act of the senator's staff member. The TikTok video even had accompanying music and narration. So, okay, the video became viral. Can the staff member be liable for theft of the mobile phone? Explain briefly. You know, dito, nahuli siya sa akto, kinukuha niya yung mobile phone. No? At kinuhanan pa niya ng laman, no? Kinopya niya. So let's take a look at how we can improve on this particular thing. Our suggested answer, yes, the staff member is liable for theft of the mobile phone. The taking of the cell phone without the resource person's knowledge and approval constitutes theft. To me, this straightforward to sentence answers is more than sufficient already. If you mention something about the act of returning did not negate the the theft, is to my mind unnecessary. Hindi naman tinatanong yun. Oo. If the examiner would like to really focus on the accurate answer, yan lang. Gusto lang niya malaman pag kinuha. Yung whether sinuli o hindi sinuli is already irrelevant to the question. Pero kung nilagay, hindi naman mali. Kaya lang overkill. Okay? Hindi naman siguro mamali. Pero yun ang mga klase ng hindi dapat na dinadagdag para hindi na mahirapan yung examiner mag-correct. At kayo rin, simple lang ang sagot. Okay, so that is question number 3 under the revised penal code. So let's go now to question number 4. And it says robbery. Ano kaya mayroong robbery dito? One Sunday afternoon, while standing at the corner of C.P. Garcia and Katipunan Avenues, an off-duty police officer accosted a motorcycle rider and asked them to alight. The off-duty police officer then inspected the motorcycle's compartment box. Pretending that a sachet of shabu was found, The off-duty police officer demanded 1,000 in order to prevent an arrest. Fearful of being incarcerated for life for a crime that was not really committed, the motorcycle rider readily complied. Unknown to the off-duty police officer, a surveillance camera caught the entire incident. Will a charge of robbery prosper against the off-duty police officer? Explain briefly. Our suggested answer: yes, the police officer can be charged of robbery with the aggravating circumstance of taking advantage of his public position. Again, importante na naman naka-highlight kasi when you prepare, if you are the public prosecutor and you prepare the information, when you don't put this in, no, then the aggravating circumstance of taking advantage of position will not be considered anymore. Mababypass na yun. So, a complete answer should mention that. No? And it says, the police officer is guilty of robbery. Why? For taking the motorcycle rider's personal property, the 1,000, with intent to gain by means of intimidation. Yun. Maaring wala ngang force pero may intimidation. That would already be robbery. Threatening to arrest the rider for the planted shabu. The offending police officer took advantage of his public possession as an aggravating circumstance. Yan ang suggestion natin na hindi lang kinukumpirma natin na there is robbery to intimidation, there is also an aggravating circumstance of using the position of officer as for a public position. It doesn't matter whether he is on off duty or on duty. The fact of the matter is, nagpakilala siya ng police officer somehow. Either naka-uniforme siya o kung hindi naka-uniforme, nilabas niya yung kanyang badge. Kaya natakot yung motorcycle rider. Okay? And last question, the fifth question under the revised penal code is liberty and security. And this is problem number 3. It reads, the accused in a pending case forcibly snatched the daughter of a judge and kept her in an undisclosed location. The accused then called to tell the judge that the daughter would only be released if the judge would acquit the accused in the pending case. Did the accused commit a crime with these acts? Explain briefly. Now, suggested answer, yes. The accused committed the complex crime of grave coercion through serious illegal detention. The judge is being compelled to acquit the accused against his will by forcibly snatching his daughter and depriving her of her liberty. The serious illegal detention or kidnapping committed on a female is necessary for committing the grave coercion. Tingnan nyo, no, while ina-assume natin yung judge bibigay, no? And so therefore there is this grave coercion. He was being asked to do something against his will. But that was achieved only by using serious illegal detention. So complex crime ito. The serious illegal detention was necessary in order to push the grave coercion. Ngayon, kaya naging illegal detention kasi female, and that is contained in the revised penal code. Pagka female ang kinidnap, syempre, merong effect yun na that becomes now serious illegal detention. Kung hindi naman female yun, no, ano lang yun, ordinary, simple lang yun. Simple, what they call this, illegal detention. Pero pag female, serious illegal detention. And there is where the citation is, grave coercion under Article 286, serious illegal detention under Article 267, Paragraph 4, and then yung complex crime under Article 48, Section 1. Okay. So medyo may konting masasagot, pero hindi kompleto, maaaring ilagay yung grave coercion. Ang madaling ilagay dito yung serious illegal detention. Maaaring dugtungan din ng grave coercion, pero baka yung magagaling, sila makakapagdugtong ng complex crime. Yung dalawa. One becomes the means to achieve the other. Kinidnap para masindak yung judge. Okay? So, the only question on complex crime. And obviously, that is something that is expected to be known by the candidate. So, that essentially ends up our 5 questions. Kanina sa Principles 5, dito sa Revised Penal Code 5, you know. And so, pupunta na tayo dun sa summary table para makapunta tayo dun sa special criminal laws. So, mostly MALUM, PROHIBITUM. Tingnan natin. In the special criminal laws, what was given is Republic Act 7610, Special Protection of Children, Republic Act 9262, yung Anti-Violence Against Women and Children, the Republic Act 1017 on data privacy, Republic Act 11313 on the safe space, and then Republic Act 4103 on the indeterminate sentence law. Ito medyo pamigay. No? But let's take a look at now the special protection of children. So ito, 1, 2, 3, tigli 5, no? 5, 5, 5, 15 ang binigay na questions. Okay. Let me just double check na 15 nga. No? I have here the complete printed questions. Oo. 15 lang. Ang huling-huli yung PRAETER INTENTIONEM. So tingnan natin dito yung special protection of children under Republic Act 7610. Here is the problem. It says special protection of children, child abuse. To motivate their 8-year-old daughter to study well and have a better future, and parents resorted to making her kneel on rice spread on the floor, spanking her with a bamboo stick, or requiring her to stand in the rain for hours if her grades fell below 80 in any subject. Did the parents commit a crime? Explain briefly. This is problem number 5 in the bar examination. Our suggested answer, yes. The parents committed physical abuse and cruelty consisting of the child's kneeling, spanking, and standing in the rain in violation of the law on special protection for children. And you will notice here, mga kaibigan, the objective is for the child to study well so that she will have a better future. The end, which is this one, very worthy, does not justify the means. Huwag mong gulpihin, huwag mong palurin. Sakit-sakit naman nun. Sabi mo, kailangan maging valedictorian ka. Pag mababa grade mo sa 80, lumuhod ka dyan sa bigas. Pagkatapos, hambalusin ng bamboo stick. And then, stand in the rain for hours if your grade is below 80. I remember a very charming lady who was my cardiologist. Sa tagal na paghihintay ko kung minsan doon sa heart center to get my anong tawag dito, yung schedule. I had the chance to look at her credentials. Alam ko, at that time that I was, and she was very senior already, even in terms of years. At the time she was my cardiologist, she was also taking care of the Secretary of Health, si Secretary Asurin. Kung hindi man magaling ito sipin mo Secretary of Health, siya yung cardiologist. Ayoko magsugal doon sa aking kalagayan, 35 years old. So, I asked her if she can be my cardiologist, and she did. So, alam ko, she was president of the Philippine Heart Association the Association of Heart Specialists. Tapos head pa siya ng medical staff ng Philippine Heart Center. Sabay, doon lang mabigat na yun. Until I was watching her mga certificates and diplomas. Ang unang nakita ko, elementary, valedictorian. Valedictorian. High school, valedictorian. Anak ng ngweteng ako. Sinunod-sunod. Tapos, Bachelor of Science in yung pre-med niya. Summa cum laude. Anak ng pusa ako. Pre-med, summa cum laude. Eto nasyak ako. Medicine proper. Summa cum laude. Abay ng waiting. 4 na academic trips. Puro number 1 siya. Pagkatapos, kumuha ng medical board. Number 1 in the medical board. Puta na ako. Paano mong tatalunin ito? Sobrang galing nito akong babae. Ang tangkad pang babae. At you can see na, barkada pa niya si Melda Marcos. Kaya makikita mo talagang may sinabi. And then, what is surprising is I saw her picture when she was in college. Anak ng waiting. Miss UST Varsitarian. Ay, may bihira naman ang Miss Varsitarian ng UST na hindi maganda. Oo. So, lahat ng qualifications nasa kanya na. And she had that kind of aura na pagka pasyente ka niya, umupo ka dyan, examining ka niya, gano'n. Trabaho lang talaga. Most of the time, dadating ko na 6, alas 8 na kumisan ako matitingnan. And she was like that. She was very formal, walang imik. Gabi na nga. One time, I took the risk of talking to her. Medyo matagal-tagal na rin ako nagpapagamot. So I said, Doktora, tinignan ko yung qualifications mo. Elementary, valedictorian. High school, valedictorian. Sabi ko, pre-med, summa cum laude. Medicine, summa cum laude. Board, number 1. Tapos Miss Varsitaria ka pa ng UST. Sabi ko, hindi mahina. UST is a leading medical school. Medyo na-touch siguro siya na ako lang yung naglakas loob na magbanggit mo. Kahit naman ganun ang kanyang taas ng pride niya. Tao rin naman siya. Sabi ko, Doktora, paano mo ginawa lahat yun? She was very good also in psychology. Bakit? Ikaw naman accounting, summa cum laude ka din Sabi niya, honor student ka rin sa UST. Hindi ko kinaya yung valedictorian elementary high school ka. Tawanan kami. And so I said, pero Doktora, paano mo ginawa yun? Perfect. Sabi niya, alam mo, Joe, my father is a mathematics and engineering professor in Mapua. Engineering. So whenever I go home, I bring my card. He looks at my card and he always has a consistent, difficult question. How many points are you ahead on the next one next to you? So, ang tinatanong ng tatay, ilan ang buffer zone mo sa grade mo doon sa susunod? Hindi na pinag-uusapan na number 1 ka. Tatawa kasi sabi niya, alam mo, Joe, sabi niya, talagang ang target to doon, lampasan talaga ng gusto yung dahil i-justify ko, 1 o 2 points na kalaman ko, patay ako sa tatay ko. Natawa naman ako, I remember this problem. Hindi ko naman natatandaan, pinaluhod siya sa bigas. Hindi ko naman natatandaan, pinapalo siya ng stick. And at the same time, not her, what you call this, she doesn't stand on hours. Pero sabi ko, grabe. So she was the one that, she served also as my idol. Kaya, normally, hindi ako bilib sa mga babaeng doktora. Pero, pag gano'n naman hindi mo na titinan kung babae o lalaki. Talagang magaling. And after a while, I showed her that I was following the regimen. Naka-PowerPoint chart din yung aking mga blood pressure. And so, sabi niya sa akin, one time when I passed after 2 years, I passed the treadmill. Medyo nakakagulat yun. Sabi niya, Joe, you are my most intelligent patient. You really are intelligent and use intelligence to take care of yourself. And you're able to really discipline yourself. Sabi niya, tinan mo, lumusot ka. Happy na ako. Biro mo, ganun kagaling na doktora, pupurihin ka na sa nagawa mo. That was what gave me the courage to tell her after a while, Doktora, can I ask permission from you? Sabi niya, ano yun? I want to go back to school. Sabi niya, matanda ka na, 35 ka na, 37, 38. Sabi niya, ba't ka mag-aaral? Ano gusto mong pag-aralan? Sabi ko, law. That was the first time I saw her. Ang talim nung tinitigan ng what? Sabi niya, law. Sabi niya, why? You want to kill yourself? Sabi niya, hindi naman o, doktora. Why do you want to take up law? Yun po ang childhood dream ko. Even if kamamatay mo, sabi niya, sana po, doktora, malagay man lang sa lapid doon na attorney. Si attorney po lolo ko, ang father ko, almost became a lawyer. It's always been my childhood dream. Sabi niya, Joe, I promise you, sabi niya, if you go to law school, you will die in law school. Hindi, tahimik kaming dalawa. Matinding tingin niya sa akin. Talagang matalim. Sydney, you know, I know the life of a lawyer because my husband is a lawyer and my son is also a lawyer. And sabi niya, my husband was reviewing for the bar when we got married. That's why I know how difficult it is. Assuming matsambahan mo, hindi ka mamatay, sabi niya. You know how stressful it is to be a lawyer. Puro away yan, puro stress yan. Sabi niya, that is not for you with a weak heart. Sabi niya, may pamilya ka pa. Mabigat yung career mo, sabi niya, under pressure. Sabi niya, talaga bang gusto mo ikamatay yan? Sabi niya. Sabi ko, doktora, kung yun mo kailangan. Guys, I'm telling you, this is not the first time I've said this, probably third or fourth time I have this recording. I mentioned this. Just to let you know that if you are determined to be a lawyer, you should never give yourself an excuse na marami kang trabaho, wala kang oras mag-aral. No, if you want to be a lawyer, if yun sinasabi sa akin, diretso lang ang aking you will die in law school. Oh my God, that was about when I was 38. When did I slow down din ako? I went back to, I finally took my law when I was 14. Alam mo, mga 38. 40. Hindi, yung kantsaw ni Dinsel Ledonio Somson. Nandito ka pa. You know? Ngayon, tanungin niyo ako ngayon. You're seeing me in this lecture. Nandito pa ako. Abogado. Dean pa ng College of Law at nakikipag-iskrimahan pa sa inyo on criminal law. Ayan. Kasi mga kaibigan, I would really be very happy to see you become lawyers. And please do not give me the excuse, working student kayo, may sakit kayo, wala kayong pera. You tell me whether I can accept your reasoning. Anyway, napag-usapan lang natin. Pasensya na kung minsan nagsisingit ako ng ganito. It is really to challenge any one of you who will give the excuse na working student ka, duling ka, bingi ka, pilay ka, o wala ka namang honor nung ikaw yung nag-aral. Pag pag ito si Dean Bisquera sabi sa iyo, ang dinanas ko 47 years old dapat patay na ako. Tapos gumraduate pa. Cum laude, no? At walang sip-sip sa professor yan. Bibigyan ako ng grade na 175, kailangan 125. Anyway, maraming salamat. Pagtsatsagaan nyo makinig sa akin dito. This particular story reminded me of Doktora Abundo. Oo. Her name is ang maiden name niya is Paulino. So she's Doktora mumultuhin ako, nakalimutan ko bigla yung kanyang first name. But her maiden name is Paulino and her husband's surname is Abundo. And so, on the next question, napahaba ng konti ang kwento ko. On anti-violence against women, tingnan natin kung paano binigyan ng problem ito. Problem number 6. An estranged married couple decided to separate. As part of their amicable settlement, they agreed to ask their 14-year-old child to choose a parent with whom to live. The child chose the mother. Displeased The husband ceased providing for the child's tuition and the wife's support. The husband was a vice president of a highly profitable company. Did the husband commit any crime? Explain briefly. My suggested answer, yes. The husband violated the law on anti-violence against women and children through economic abuse. This consists of not providing for the child's tuition fee and the wife's support. Those two acts of not providing for the child's tuition fee and wife support fits into the definition of economic abuse, which is one of the abuses defined in the anti-violence against women and children. Okay? So, I don't want to prolong the discussion anymore here. Malino naman yon. Third problem under Special Criminal Law is the Data Privacy Act. Tingnan natin kung anong tanong dito. This is problem number 7 on the Data Privacy Act involving sensitive personal information. The head of a big company's human resources division copied and shared an employee's physical and email address, birth date, civil status, and some photos of a friend who found the employee attractive. Did the head of the Human Resources Division commit a crime? Explain briefly. My suggested answer, again very short. Yes, the Human Resources Division head committed a violation against the data privacy law for unlawfully processing through copying then sharing the concerned employee's sensitive personal information without her consent, said processing being legally prohibited and no permitted condition is present. Yan lang sagot. Since ano yan? Tawag dito, nasaan ba yung keyword na gusto kong sabihin dito? Yung legally prohibited and no permitted condition. Yan. So no unlawful processing ito. Confidential is what I was looking for but I did not put it there anymore. Hindi pwede. And the next problem is Safe Space Act. Ito yung tinatawag na walang bastusan act. No? Okay, let's take a look at the problem given in this particular subject matter, a special law. It says Safe Space Act. Problem. While a person was passing through a construction site for a new Hall of Justice building, construction workers shouted, "Hoy bakla! Halika dito at haplisin mo ako. Hoy bakla! Ang pangit mo! Bakla! Mukha ka pa ring lalaki kahit anong gawin mo." The person victimized by these remarks asks you, was a crime committed by the workers who shouted these statements? Explain briefly. My suggested answer, yes. A gender-based sexual harassment offense has been committed against a presumed transphobic, homophobic person by way of catcalling, unwanted invitations, sexist slurs, persistent unwanted comments on one's appearance. Sabi niya, pangit ka. The use of words, gestures, or actions that ridicule on the basis of sex, gender, or sexual orientation, identity, and or expression. Yan. Gender-based sexual harassment. Okay. And finally, ito giveaway, yung indeterminate sentence law na matagal natin encounter, hindi naman natin naintindihan until the simple question. This is problem number 12. A crime defined in the revised penal code is punishable by Aresto menor. Finding the accused guilty beyond reasonable doubt of the crime, should the judge apply the indeterminate sentence law? Explain briefly. Our answer, no. The judge should not apply the indeterminate sentence law, which is applicable only when the sentence is more than 1 year. Aresto menor is only 1 day to 30 days imprisonment. That is how short our answer is, and no controversy. And so, ladies and gentlemen, that would be the 5 problems under special criminal law. And so we have covered the 5 questions under principles of criminal law. We have covered 5 questions under the revised penal code and 5 questions in special criminal laws. To my mind, ladies and gentlemen, again, just like the questions on political law, the questions on civil law, commercial law, and taxation and labor law, the questions are not easy. But the questions are not also impossible. A regular law student, whether you're a full-time student or a working student, and you do your job well of studying, for purposes of proving to Associate Justice Marvin Leonen that you deserve an entry level into the legal profession, the question in criminal law were also reasonably fundamental. Nandiyan naman talaga. Ang medyo nakakapwing lang ng konti sa special criminal law. Pero sa principles of criminal law, basic. Sa revised penal code, ang medyo nakakapwing doon, nakita ko na yung dalawang sumagot, rape at yung child abuse. I digress with them. Ang sagot ko simple seduction lang. Bahala na examiner kung sino paniniwalaan niya. But with this, ladies and gentlemen, I'd like to really thank you very much. May mga side comment ako, medyo mahabang side story. But these were all relevant to the issues that were at hand. So, isa na lang po yung utang ko sa inyo. Lahat yun, excited kayo kasi pinakamalaking mortality yun, yung tinatawag natin na procedural law, which also included yung legal ethics. I have already done most of it, no? And I will just finalize it in this kind of diagram. Siguro in about couple of more days, 2 or 3 days, lalabas na rin yun. So, the fact that I was unable to come to your aid because of the little statics I had before the bar exams and immediately after, I hope I'm able to come up with some respectable basis for you to review. Napansin ko, dahil late nga ako, hindi ganun karami yung hindi pa ganun karami yung viewers natin dito sa mga suggested answers. Siguro, napagod na yung mga examinees, no, dahil 1 month na. Baka pagka ginaganahan kayo ulit, pasadahan nyo, compare your answers because now that you have already relaxed, siguro mas malamig na yung ulo nyo, mas maaalala nyo kung yung mga bar examinations. And for those who will be preparing for the next bar, I hope this approach is helping you out. So maraming pong salamat. I love you very much. Continue to patronize and at any time na you have the opportunity, please pray for all of us and pray for our own fellow human beings in Ukraine. Medyo hindi ko alam kung kaninong side nyo nakukuha, pero parang ang sympathy ng buong mundo is for the Ukrainian people. Oo, dahil dehado sila, but they're fighting very hard. In fact, meron na pinadalang message sa they are expecting daw everybody in Kiev, the capital, is expecting the Russians to really put their entire force anytime now, any hours now. And sabi, every man, every child, bata, babae, nakahawak lahat ng baril, they will defend. And the whole world is impressed with the way they will fight for their land and for their country. And I remember, in closing, we Filipinos are one of the bravest and one of the most stubborn fighters for our country. Nakita nyo naman, itak lang, gulok lang. No? Lumaban sila Bonifacio sa mga Kastila na ilang taong inalila tayo, inapi tayo. Pati yung mga Amerikano, hindi nila inatrasan. But the Filipino was fiercest when in the Second World War, when the Japanese came here. Alam mo, yung mga Hapon, mahirap mong i-underestimate yung samurai, yung samurai tradition nila, patay kung patay, fanatical din sa kanila. But for the first time, pumasada sila, nakita nila yung mga Malays, sinagasaan nila yung anong mga countries, no? Yung mga Inchik. First time nila nakasagupa ang Pilipino. And they saw how brutal the Filipino can fight. Kaya merong isang tao sa history, ang pangalan ni General Douglas MacArthur. And he asked that the Filipinos be allowed to fight in the Korean War. Nilagay sa front line, 10th Battalion Combat Team. Yung mga katabi natin, mga other United Nations soldiers, at the onslaught of the attack of the Red Chinese Army, atrasan sila. Yung Pilipino nandun sa hill. Walang umatras na Pilipino. Nasindak yung mga Inchik na putrang na lusob, wave by wave. Walang umaatras na Pilipino. Of course, I think two of their commanders, detachment commanders, was skilled. And then, sumunod na yung 10th Battalion Combat Team, 10th BCT. Tapos, dumating na naman yung I think 20th BCT. And the greatest American Caesar gave his complimentary comment to the Filipino soldier when he said, "You give me," sabi niya, I think a battalion of Filipino soldiers, and I'm willing to fight anytime, anywhere with them. Antindi. Kaya pa yung mga Pilipino, hindi tayo basta-basta. We should be proud of our nation. We are known to be fighters. Kahit yung mga kapatid natin sa Mindanao, yung mga Muslim brothers natin, I am very sincere in saying, kung meron tayong dapat kilalahanin na matatapang at matibay, yung ating mga Muslim brothers, pag tumabi tayo sa kanila, Pilipinong-Pilipino, yung nagkataon lang ang relihiyon nila, Islam, relihiyon natin, nabuwala tayo ng mga Kastila, naging Katolik. But we should love each other, and we should continue to appreciate that we have brave Filipinos. No? We have a brave Andres Bonifacio, we have a brave Antonio Luna, we have a brave Francisco Dagohoy, we have a brave Diego Silang. Ahead of them was a brave Lapu-Lapu. Ang dami mga heroes natin na hindi natakot, hindi umatras. Kaya wag nilang mamaliitin ng Pilipino. And one day, when we rise slowly to show the world that we deserve that kind of respect that belongs to us, we will rise. Mahalin natin ang bayan natin, mahalin natin ang sarili natin, and let us be proud. Meron na nga nagsabing Pilipino, the only one who dared to say, this nation can be great again. Sana buhatin natin yung salita niya, buhatin natin ang bayaning Filipino, and we fight for our nation so that one day we become wealthier, more happy, and more proud. Marami pong salamat for giving me the opportunity to say my little piece here in this little YouTube. Pagka minsan nabubisit kayo, putulin nyo na, huwag nyo na pakinggan. So, thank you very much. And sa akin, good night na ito. It's almost 12 o'clock and I am so happy to have already uploaded yung huling-huling second to the last na bar examination question.